Hey guys, my name is Joel Williams. Today I want to talk to you about Georgia's borrowed servant doctrine and whether it may apply to a civil case that you're working on. If this video is helpful to you, we appreciate you subscribing to our page, giving us a thumbs up in the section below, or leaving us a comment to let us know what you think or feel about the tips that we give you in this video. Of course, most lawyers know that Georgia's Workers' Compensation Act provides benefits for employees who sustain injuries that arise out of and occur within the course and scope of their employment. Most lawyers also realize that those workers' compensation benefits are almost always the employee's exclusive remedy against the employer. But what happens when an employee is injured while doing work for someone other than his or her normal employer, and the injury is caused by the negligence of the other person or company? If the employee was on loan to the other person or company, lawyers should always consider whether the borrowed servant doctrine will bar any personal injury claim against the person or company that the employee is helping. The borrowed servant doctrine is a narrow exception to traditional respondent superior liability. In order for an employee to qualify as a borrowed servant, the evidence must show that 1. The special master had complete control and direction of the servant for the occasion, 2. The general master had no such control, and 3. The special master had the exclusive right to discharge the servant. If a defendant can show that the borrowed servant doctrine applies, the employee's exclusive remedy would be a workers' compensation claim, and any third-party claim would be barred. Ordinarily, the terms of any borrowed servant relationship is expressly contemplated and spelled out in a contract. Well, when there is a written contract, Georgia courts will almost always use the contractual language to determine whether application of the borrowed servant doctrine is appropriate. Therefore, attorneys who are drafting contracts of this nature should always be careful to include the elements of the borrowed servant doctrine in the contract. However, the most interesting cases to litigate are those where the doctrine is not expressly set forth in the contract. In those situations, courts look to the specific facts of each individual case as well as the relationship between the hirer and the employee. Remember, a defendant raising the borrowed servant defense must prove all three prongs of the test. The first being, 1. The special master or borrowing person or company must exercise complete control and direction over the servant for the occasion. Just giving instruction or assistance to another does not establish complete control. For example, in Alta Refrigeration versus Amerigold Logistics, a Georgia Court of Appeals case from 2009, the court held the right to control means the right to tell an employee how he shall go about doing the job in every detail, including what tools he shall use and what procedures he shall follow. A perfect example of complete control is given in the case of Preston versus Georgia Power Company, 227 Georgia App 449, where a worker was supplied to a different company by a temporary labor agency. Of course, temporary labor agencies are in the business of loaning their employees to other employers for temporary times to do a job for the borrowing employer. It's hard to imagine a situation where a borrowing employer would not control the time, manner, and method of the job performance from a worker supplied by a temporary labor agency. Another important case to be aware of is Six Flags Over Georgia versus Hill. It's 247 Georgia 375, 1981. In Six Flags, 2 workers were supplied to Six Flags by the company that built the Mindbender roller coaster. The workers were to do repair and maintenance work on the roller coaster. Now, the plaintiff was one of the 2 workers. On the day the plaintiff was injured, he was working under the direct supervision of a Six Flags employee who specifically requested that he help dislodge one of the roller coaster train rides. During the temporary task of dislodging the train ride, the Six Flags employee supervised and directed the manner and method of how the plaintiff dislodged the train when a cable snapped and injured the plaintiff. The court specifically noted that it was not concerned with whether the plaintiff was always under the control and direction of Six Flags, but whether he was on the occasion when the injury occurred. The court even quoted the Restatement of Agency 2D Section 227, holding that a servant directed or permitted by his master to perform services for another may become the servant of such other in performing the services. He may become the other servant as to some acts and not as to others. This tells us that we have to determine whether the servant was under the complete control of the temporary master when he or she was performing the task at issue. That leads us to the second prong. The general master had no such control. Basically, this means that the servant's general employer had to relinquish complete control of the employee for a particular task. If the general employer retains control or shares control over the servant, the borrowed servant doctrine will not apply. The third and final prong of the borrowed servant doctrine is the special master had to have exclusive right to discharge the servant from the task at hand. The case of Garden City versus Herrera from 2014 tells us that the right to discharge means that the special master must have the right to discharge the servant from his particular work. Garden City involved a multi-jurisdictional agreement between Garden City and Chatham County to form a counter-narcotics task force, which was formed, managed, and controlled by the county. Under the terms of the agreement, Garden City expressly reserved the right to assign one of its police officers to the task force for a tour of duty, and when assigned, conferred exclusive directive supervision and authority over the officer to head the task force. Now, subsequent to the agreement, the city assigned one of its officers to the task force who was involved in a motor vehicle collision that caused serious injuries to the plaintiff. The plaintiff sued the city and the county, among other defendants. The city then moved for summary judgment, asserting that the officer was the borrowed servant of the county at the time of the incident, which was denied by the trial court. The Court of Appeals reversed the trial court reasoning that the agreement controlled in determining the police officer's employment status because it expressly addressed all three prongs of the borrowed servant rule. Specifically, the court found that the county, as the borrowing employer, pursuant to the agreement, had the unilateral right to discharge the police officer from the county's task force. Therefore, the third prong of the borrowed servant doctrine applied. I hope this video has been helpful to you in understanding the borrowed servant doctrine and when it may apply in the state of Georgia and all of the elements that's contained in it. If it has been helpful to you, we'd appreciate you letting us know by giving us a thumbs up if you're watching this on our YouTube channel. If you have any other insight or know of any other cases that might be helpful to other members of the bar, we'd appreciate you citing those in the comment section below. Or if you think anything we've said during this video is incorrect or outdated, please let us know that in the comment section below as well. Finally, if you have any other ideas about legal matters that might be helpful to fellow members of the bar, please let us know in the comment section below or give me a call at 404-389-1035. I'll do my best to get a video out on that topic as soon as we can. Thank you so much.